Good afternoon and welcome to the Crone Law Firm Facebook Live show. My name is Alan Crone. I'm the founder and managing partner of the Crone Law Firm here in Memphis, Tennessee. We're an employment law firm and we represent employees, executives, and entrepreneurs in any dispute that affects their ability to make money, whether that involves compensation, overtime, minimum wage, wrongful termination, disputes between business partners, commercial disputes, and hostile work environments and sexual harassment, which is what we're going to talk about today. I appreciate everybody joining us on a Friday afternoon, which is atypical. Normally we're doing these on Thursday, but here in Memphis we've been celebrating and remembering the life and assassination of Dr. Martin Luther King 50 years ago this week. And we've been involved in that, and yesterday was very hectic for us, so we decided to move this show to Friday afternoon. But we're going to try to stay with Thursday afternoons, every other Thursday afternoon, as we've been doing. So I appreciate everybody joining us this afternoon. In the news and in the popular media, there's a lot of talk right now about sexual harassment with things going on with the President of the United States and out in Hollywood, the Me Too movement and all of those things. And we've been getting a lot of calls and a lot of questions about exactly what all of that means for regular people working in jobs all across the country. And so we thought we'd take some time this afternoon to explore 4 or 5 frequently asked questions that people have, and hopefully this helps someone. If you have an issue like this, I really recommend that you go see an attorney, whether it's us or somebody else, about it, because each situation is very unique. Each situation is extremely important. It's important that employers don't foster an environment of sexual harassment. And it's particularly important that employers don't base hiring, firing, promotion, retention decisions on the basis of sexual harassment, or what we in the law call quid pro quo harassment, which is, if you do something for me, I'll do something for you. And that's not right. It's illegal. And if you're suffering through that right now, I'm really sorry, because I can't imagine how terrible that would be. But please go, whether it's us or someone else, please go see an attorney about that. Our number here is 901-737-7740. That's 901-737-7740. Or you can email us at firm@cronelawfirmplc.com. And of course, our website is cronelawfirmplc.com. So without any further ado, let's get into the questions. The first question is pretty straightforward. What does it mean to be sexually harassed at work? That, again, as I said, that's the answer to that question is really kind of a case-by-case scenario, because no harasser is the same, no environment is the same, no person is the same. But basically, sexual harassment is any unwelcome conduct or language that affects your ability, that's based on your sex, that affects your ability to do your job correctly. It can take many, many formats. It can take the format of someone belittling you because of your sex or your gender. It can take the form of propositioning, comments about your appearance, comments about your sex life. I had one case several years ago when I first started doing this work, where my client worked for a financial trading firm. And one of the witnesses in her sexual harassment trial talked about how she would prepare herself mentally to go on to the male-dominated trading floor. My client was the only female trader, and this particular witness was a trading assistant. And she used to say that before she would open the doors of that trading floor, that she would put on her mental armor so that she could walk that gauntlet and not hear the comments that were being made. And it was very powerful testimony. And so I always say if you're in a truly sexually harassive environment, there's no way to mistake it. I'm not talking about a joke here and there. I'm not talking about someone complimenting another person on their appearance, although those are kind of gateway conversations that can morph into sexual harassment. But what I'm really talking about are two kinds of things. One is the environment that as we've discussed, comments, suggestive posters, anything that degrades women or anything that tries to make sex and their sexuality an object. The other is what we described as quid pro quo sexual harassment, and that is when a supervisor is asking for sexual favors, the supervisor is joking or maybe is serious that if you exchange sexual favors, then promotions become easier, that sort of thing. And the two can kind of overlap a little bit because if you're getting a lot of attention sexually from a coworker or a supervisor, that can turn into quid pro quo harassment, but it also can be the basis of a claim in and of itself. And so that raises the question, what should I do if I'm being sexually harassed at work? And the answer to that question can be very, very difficult, because the answer is you need to report it. If it's a coworker, or if it's a coworker particularly, the law requires that you report it to the company so that they can take appropriate action. And that if you don't, it's like it never happened, as far as the company is concerned. Because if you can't prove that the company knew about it, then there's no obligation on the part of the company to try to remedy the situation, and therefore you don't have a claim against the company if you decide to bring an EEOC charge or a lawsuit. If it's a supervisor, then you may or may not, depending upon the circumstance, you may or may not have to alert the company beforehand, say before you go outside. Although it still is a good idea. I always say you want to give the company the ability to do what's right. And again, that's going to depend on your particular circumstance, because companies of a certain size, several hundred employees that have a robust and mature human resources department, they're going to react to these sorts of complaints differently than a smaller operation, where the person that is the harasser may be the person you'd be expected to report it to, whether it's the owner of the company or a senior manager or the brother of the owner of the company or what have you. So in that circumstance where you're not comfortable, I would reach out to an employment lawyer and tell them your situation and get some advice on exactly how to proceed, because the first step is to stand up to it. And the first step might be just to let the person know that you're talking to or that's dealing with you, look, I don't appreciate this at all. Maybe put it in an email. The comments that you've been making lately about me make me feel uncomfortable, and I wish you would stop. And then maybe you copy your supervisor or HR on that email. And if they continue, then you can go to HR or your supervisor and say, I tried to take care of this informally, but that didn't work. Now I need more formal help in order to take care of this situation. And if the company turns a blind eye to it or doesn't agree with your complaint, or they do an investigation and tell you, well, we investigated it and we can't find any evidence, so we're not going to do anything, then you really may want to consider going to the EEOC or going to a private attorney for some intervention at that point. And again, depending upon your circumstance, a private attorney might recommend, well, let's just write a letter and see if that doesn't take care of it, so that you can escalate towards filing an EEOC complaint. And by the way, EEOC, sometimes we lawyers talk in acronyms, but it stands for the Equal Employment Opportunity Commission, and that's the federal agency that's tasked, among other things, with investigating claims of sexual harassment. The next question is, how are bullying and sexual harassment similar? And that's a really good question, because all sexual harassment you could probably qualify as bullying, but not all bullying is sexual harassment. I mean, the first distinguishing characteristic is to be sexual harassment, it has to be aimed at your sex or your sexuality. So if you have someone who bullies everybody, male, female, then that may not be sexual harassment. It may not even be illegal under the federal employment statutes at all if that bullying is aimed at everyone indiscriminately or many people indiscriminately. But if it's aimed at just at women or just at men because of their sexuality, then that becomes a basis for sexual harassment. And I see a lot of people who come to see me who are in abusive, it's the only word I can use to describe it, employment relationships with a supervisor or coworker, where they're suffering really egregious conduct that's not illegal as far as the company is concerned. The company isn't culpable because it's not aimed at them because of their inclusion in a protected category. So not all bullying, not all hostile work environments are actionable or illegal, but all that are aimed at you because of your sex or sexuality can be sexual harassment. And it has to be persuasive, and it has to be unwelcome. So sometimes a defense to sexual harassment is that the victim allegedly participated in the conduct. If it's jokes, or if it's sexual talk, or if it's a consensual affair, then it's not. The defense will be it's not unwelcome. And then the other part of that is it has to be pervasive. It can't just be what they call a stray comment. It can't be once every so often. And I find it's very helpful if clients will keep a diary or a journal of what happened so that they can remember the details later. Frequently, I've seen in depositions where clients have been asked, well, tell me every time this happened, and they think, and they can only remember 3 or 4 occasions, and they're really subject to dismissal because they can't prove that the conduct was pervasive, particularly when the harasser, and this frequently occurs, where the harasser waits until it's just the victim and the harasser together, so there are no witnesses. That's another time when the victim really needs to have a good recall and to be able to describe in detail what happened, even if it's just a statement that, well, this happened all the time. I can give you a few examples, but it happened daily, or it happened twice a day, or once every couple hours. The more often that the conduct happened, the more likely it is to be actionable as sexual harassment. The next question is, what is the EEOC, the Equal Employment Opportunity Commission, and what does it have to do with sexual harassment? Well, the federal law, Title VII of the Civil Rights Act of 1964, is what governs these interactions and makes this conduct illegal. And that act requires that any claim that's going to be brought under the act has to be brought first at the Equal Employment Opportunity Commission. They are charged with investigating the conduct and deciding whether or not they themselves will prosecute or give you what's called a right to sue letter. And then you can go get a private attorney and bring your own private lawsuit. In recent years, the EEOC has also added another very important service, and that's an early mediation service. And mediation is a process by which a neutral party helps two parties to a dispute resolve their dispute. And I have found that frequently, whether it's a sexual harassment situation or a wrongful termination, that mediations done at the appropriate time can be very, very effective way to resolve the dispute. Sometimes if you try to do it too early, when both sides don't understand the claims, it may not be effective. But more often than not, if both parties come to the mediation prepared to resolve the dispute in a reasonable way, the EEOC mediation process and other private mediation processes can be very, very effective. So frequently what will happen is the victim will file a charge with the EEOC, and that has to be done within 180 days in some jurisdictions or 300 days in others. For example, Tennessee is what we call a referral jurisdiction. So victims have 300 days to file an EEOC charge in Tennessee, but only 180 days in Mississippi and Arkansas and some other states. So that's another reason to do some investigation, some research, or contact a lawyer about it so you know what the deadlines are. But once you file your charge, then sometimes the claim will be assigned to a mediator before it goes to the investigations unit, and they'll attempt to mediate and reconcile the case that way. If either of the parties chooses not to participate in mediation, or you mediate the case and it just doesn't resolve for whatever reason, then it goes to the investigative arm of the EEOC. That's usually on a different floor of the building, and the investigators then will review the complaint, review the response of the respondent, the company. They may do an on-site investigation. They may ask for more documents. They'll interview the victim, the complainant, and then they'll issue either a determination that there's a violation, or they'll issue a determination that they were unable to find a violation and authorize the victim through a right to sue letter to bring their own lawsuit. And then the case can either proceed in state or federal court, depending upon the circumstance. So EEOC has a very crucial role to play statutorily. As a practical matter, I'll say that the EEOC's resources are very limited, and so they really pick and choose the kind of cases that they take. Sometimes they pick the best cases, but more often than not, the EEOC says, okay, we're going to really focus on certain kinds of cases, and that's what they're on the lookout for, and then they release all the other cases via right to sue letters. So if you receive a right to sue letter, don't assume that your case doesn't have any merit because the EEOC didn't want to file the case on your behalf. I've been doing this almost 30 years, and I can count on one hand the number of cases I've been involved in where the EEOC has filed a lawsuit and prosecuted the case themselves. It's very, very rare. Most people end up pursuing the case via a private lawyer or on their own. The final question is, what should my supervisor and company do after I complain about sexual harassment? The law requires them to take prompt, appropriate remedial measures. And what that means is the company should do an investigation. And if they determine that there was a violation, then they should address that situation. And that can be done in a variety of ways. And I'll be honest with you and say that frequently my clients are less than overwhelmed with the company's choice of prompt, appropriate remedial measures, and they disagree. They don't think they go far enough. And sometimes they're right, and sometimes they're wrong about that. But what you want the company to do is to address your complaint in a good faith way that's calculated to remove the offensive conduct and to create a better working environment. And that can take the forms of a lot of things. One is it can take the form of discipline against the alleged harasser. It can include training for the unit at issue, or for the whole company for that matter. There could be some financial component to it, although that's very rare in the prompt, appropriate remedial measure forum, but it sometimes does happen. Sometimes back pay or promotion pay is appropriate if the company determines that you were disciplined or denied a promotion improperly and that it cost you money. And sometimes companies will reimburse you for that sort of thing. And that's definitely something that you should ask for in your complaint if and when they ask you, well, what is your goal? What's your appropriate remedial measure here? One thing I'll say that is not universal, but things that I frequently see is I think many times victims have an expectation that the company will come back to them and report on the outcome of their investigation or report to them on what the appropriate remedial measures were. And the law is a little murky on whether they're required to do that. I can tell you that frequently companies don't make those reports back, and I think it's a mistake, at least on the level that frequently victims find out only much later that the company took certain actions, and if they had known that the company had taken those actions early on, they may have been less inclined to pursue legal action. So companies aren't required to, and they're also not required necessarily to maintain a high level of confidentiality. And I'll say that that's a tough road for a well-meaning company to walk, because their inclination is they want this to be confidential. They don't want to smear the name of either the victim or the alleged harasser. But over the course of the investigation, that can be hard to keep that confidential if the questions suggest what has been going on, or everybody knows what's been going on because it's just a notorious situation in the company or in the unit. So I find frequently that my clients have pre-existing expectations on the level of confidentiality, and sometimes those expectations conflict because they expect a lot of confidentiality for themselves, but they don't expect a lot of confidentiality for the harasser. In other words, they want to know what happened to the harasser. So it's sometimes we have to really have long conversations about that. Again, every situation is different, and that's something that you want to talk to your lawyer about and get that out on the table sooner rather than later, because again, I find that sometimes when those expectations aren't met in the way that my client expects them to be met, that causes problems later on with resolving the case, because my client has some unresolved issues related to the way they were treated with regards to the investigation and the way the case was handled, particularly if they're not given a report on the outcome. And weeks or months go by and nothing happens, and frequently people translate that into, well, I made this complaint, nothing ever happened about it. Well, that may not be accurate. All too often, frequently, that's exactly what happened. They made the complaint and nothing happened about it. But sometimes I find that the company did, in fact, take some appropriate remedial action, but they, for whatever reason, decided not to tell the complainant about it, and in fact, in some cases, even stiff-armed them and said, we're not going to discuss any of this with you. Thank you for your complaint, and we'll get back to you if we need to get back to you. So that's the main thing that companies are required to do, is to take that quick, prompt, appropriate remedial action. And that if they do that, then that may mean that no matter how bad the pre-complaint conduct was, that there's no complaint going forward if the conduct stopped as of that complaint. In a future broadcast, we'll talk about retaliation, which is something everybody is concerned about. Companies are required not to retaliate if you make a complaint, but frequently there are issues that come out of those complaints that people perceive as retaliation, and that's a separate claim. That's a separate situation, and we can deal with those in a upcoming broadcast. Again, this is Alan Crone. I'm the managing partner at the Crone Law Firm, an employment law firm in Memphis, Tennessee. We represent employees, executives, and entrepreneurs in work-related or business-related disputes. And I hope that you all have a great weekend, and I'll look forward to seeing you on our next broadcast.